Well, good morning, everybody. Carrying on with part 3, and this is item 3. This is following on from Len Kaczynski and Michael O'Kelly. Item number 3, the May 13th, 2006 interrogation. Following the O'Kelly interview, Kaczynski arranged for the state's investigators to interrogate Dassey again. Kaczynski did not attend the interrogation. The state had not made any offer of immunity or prosecutorial consideration. Kaczynski did not prepare Dassey for the interrogation, trusting O'Kelly to do so. The plan was to have O'Kelly watch Dassey's interrogation from a separate monitoring room. Kaczynski instructed O'Kelly not to interrupt unless Dassey asked to speak with Kaczynski or otherwise asked to stop. The interrogation took place on the morning of May 13th, 2006 at the Sheboygan County Juvenile Detention Centre. Wiegert and Fassbender re-advised Dassey of his Miranda rights and confirmed that he wanted to speak with them, and that no one had made any promises. Dassey then recounted a version of the events of October the 31st, 2005. The version of events that Dassey now told differed in certain significant respects from the version he recounted on March the 1st. Dassey denied ever seeing Halbach's RAV4, riding his bike to get the mail, hearing any screaming coming from Avery's home, cutting Halbach's throat, or seeing Avery ever punch Halbach. Dassey said he did not go over to Avery's until about 7 o'clock, after Avery twice called, inviting him to the bonfire. At numerous points throughout the May 13th interrogation, the agents stated that they were giving Dassey a final chance to tell the truth. They said that they did not have to come back to listen to him and that they would leave if he did not tell the truth. At one point, Wiegert told Dassey that they knew Halbach had been in the back of the RAV4 while she was bleeding. Despite previously denying having seen the RAV4, Dassey now said that the RAV4 was backed into Avery's garage and that, after Halbach was stabbed, Avery put her into the RAV4 before deciding to burn her. According to Dassey, Avery's plan had been to crush the RAV4 with Halbach in it before anyone noticed. Just a little aside, it beggars belief when people talk about the fact that Stephen Avery had access to a crusher. All the cars that were crushed were inspected. Crushing a car is not as easy as you think. You just don't drive up, press a button. The car has to be prepared, all the fluids have to be taken out, lots of stuff has to be removed. It is not a simple job. The idea that, that Stephen Avery would just drive the car to the crusher and press a button and that's it, evidence destroyed. It ain't as simple as that. Dassey then said that Avery drove the RAV4 into the salvage yard, but that he did not go with him. Wiegert challenged him. "How did your DNA get in the truck?" "It ain't," responded Dassey. "And how do you know that?" asked Wiegert. Dassey responded, "'Cause I never went in it." Fassbender confronted Dassey with the version of events he had provided on March the 1st, where he said that he accompanied Avery in the RAV4 and described certain events that occurred there. "What, did you just grab that out of the air? How do you know those things?" "Just guessing," Dassey responded. However, later in the interrogation on May 13th, Dassey said, as he had on March the 1st, that he had accompanied Avery to the salvage yard in the RAV4. Dassey's May 13th statement contained numerous internal contradictions. For example, initially he said Halbach was shot after she was taken out of the RAV4. But later he said she was shot before Avery put her in the RAV4. Dassey initially said that Halbach was screaming when he stabbed her. Immediately thereafter, he said that she was not moving or breathing. Dassey said he cut Halbach's hair with the knife in the bedroom, but when the investigators pointed out that Dassey had just said that Avery got the knife from the garage, Dassey denied ever cutting Halbach's hair. When Fassbender asked Dassey why he had said that he had cut Halbach's hair, Dassey responded, "I don't know." When later asked how he came up with the story about cutting Halbach's hair, Dassey responded, "I don't know, I was just guessing." Wiegert told Dassey, "Your mum told me you'd be honest with me. I haven't called her yet to tell her that you lied to me, but I will do that. What do you think she's going to say to you? She's going to be mad." Wiegert asked Dassey if he was going to tell his mum about their discussion. Dassey said he probably would the next time he saw her. Wiegert asked, "Don't you think you should call her?" Of course, Wiegert knew that calls from the jail were recorded. Dassey responded, "Yeah." "When you going to do that?" asked Wiegert. "Probably tonight," said Dassey. "Yeah, I think she'd like to hear it coming from you rather than me," said Wiegert. "And if she has any questions, 'cause I'm seeing her tomorrow," Dassey responded. "Oh, she's coming here tomorrow?" Wiegert asked. Mumbled Dassey. Wiegert continued, "Then maybe it'd be a good idea to call her before she gets here tonight. That's what I do, 'cause otherwise she's going to be really mad tomorrow. Better on the phone, isn't it?" Agreed Dassey. So then, of course, item number 4, Dassey's recorded phone call to his mother. Later that day, Dassey called his mother from jail. Like all calls from the jail inmates, the phone call was recorded. Dassey's first question to his mother was, "Did you talk to anybody?" When his mother said she did not and asked him what he meant, Dassey explained, "'Cause Mark and Fassbender are going to talk to you." Yanda asked Dassey to explain what he meant. "Well, I guess yesterday that Mike O'Kelly guy came up here and talked to me about my results." Dassey asked, "Do you feel bad if I say it today?" "You don't even have to say it, Brendan," she responded. When Dassey asked why, Yanda responded, "Because just by the way you are acting, I know what it is." Dassey then made clear that they were talking about what me and Steve did that day. "What about it?" asked Yanda. "Well, Mike and Mark and Matt came up one day and took another interview with me and said because they think I was lying, but so, they said if I come out with it, that I would have to go to jail for 90 years. But if I came out with it, would probably get, I don't know, about like 20 or less. After the interview, they told me if I wanted to say something to her family and said that I was sorry for what I did." "Then Stephen did do it," Yanda exclaimed. "Yeah," Dassey agreed. Dassey expressed concern to Yanda about being able to face Avery in court and what might happen if Avery were to become angry. Yanda told Dassey that he had nothing to worry about himself. Yanda asked Dassey how he was able to answer the phone when his brother's boss called. Dassey responded, "They told me that they looked at the records and that he didn't call." "What about when I got home at 5? You were here?" Yanda asked. "I went over there earlier and then came home before you did," Dassey responded. When Yanda asked Dassey why he did not say anything to her then, Dassey responded, I don't know. I was scared. So in those statements you did all that to her, too? Yanda asked. Some of it, Dassey responded. Was your attorney there when Mark and those guys were? Yanda asked. When Dassey said he was not, Yanda responded, don't talk them no more. They are putting you in places where you're not. You know the reason they're talking to you is to get more information out of you, and what your attorney should be doing is putting an order on all of them that they cannot interfere with you or your family members unless your attorney is present. Because they're all investigators for the Holbach case, not the Dassey case. It's the Holbach case. Because the only thing that they're putting out there is bad stuff about you. And if you weren't there at the time, if you didn't slice her throat, you did not have sexual contact with her. No, Dassey responded. So if I was in the garage cleaning up that stuff on the floor, how much time will I get for that? Dassey asked. What was it? Yanda inquired. I don't know. It was this reddish black stuff, Dassey answered. So did you see the body in the fire? Asked Yanda. No, replied Dassey. You know if he killed her? Yanda asked. You know if he killed her? Yanda asked. Not that I know of, Dassey responded. Yanda asked Dassey why he lost so much weight, and Dassey responded that he was trying to impress a girl. The call ended when an automated voice broke in and cut off the call. Item 5. Court removes Kaczynski as counsel. At a hearing on August 25, 2006, the trial court discussed a letter it had received from the state public defender stating that Kaczynski allowing law enforcement to interview Dassey without counsel present was indefensible. It said that it had decertified Kaczynski from being appointed in Class A through to Class D felony matters. The decertification was prospective only and thus did not directly apply to Kaczynski's representation of Dassey. Nevertheless, Kaczynski moved to withdraw as Dassey's counsel. Dassey confirmed that he wished to have a new attorney appointed to represent him. The prosecution suggested the need for an evidentiary hearing to determine, in part, the admissibility of the statement obtained without Kaczynski's presence. The court disagreed that an evidentiary hearing was necessary, noting the institutional interest in ensuring that criminal trials are conducted within the ethical standards of the profession, that legal proceedings appear fair to all who observe them, and that the court's judgments remain intact on appeal. The court concluded that, particularly in light of Dassey's age and record of intellectual deficits, Kaczynski's failure to be present while his client gave a statement to investigators constituted deficient performance on attorney Kaczynski's part. It further stated that Kaczynski's withdrawal is necessary to assure the entire proceeding be viewed as fair and trying to ensure that we can maintain public confidence in the administration of justice and the fair administration of justice. If this case has to be tried, I want to do my level best to make sure that it is tried only once. The prosecution, the defence, the families involved, the system deserves no less. Accordingly, as I have said, I'm going to grant Mr. Kaczynski's motion to withdraw. That was what Judge Fox decided. Item D, trial. A successor counsel was appointed to represent Dassey, and on April the 16th, 2007, a jury trial commenced. Over the course of the next roughly 6 days, the prosecution presented its case against Dassey. The centrepiece of the prosecution's case was Dassey's March 1st confession to Wiegert and Fassbender. The prosecution played the recorded interview for the jury at trial. The May 13th interrogation by Wiegert and Fassbender was not discussed at trial. Dassey's defence was that the statements he made on March 1st were not true. Dassey presented his academic records that showed that, although he was in regular high school classes, he also received special education assistance due to various cognitive difficulties and had overall borderline to below average intellectual ability. Dassey's brother testified that he was at home with Dassey on October the 31st, 2005 until about 5:20 when he left, leaving Dassey alone at home. Dassey's brother's boss also testified that he called the Dassey residence on October the 31st, 2005 at about 6 o'clock and spoke with Dassey. Dassey testified on his own behalf. He said that after he got off the school bus with his brother at about 3:45, he played video games until he made himself dinner at about 5 o'clock. Dassey's mother came home around that time, and after he was done eating, he spoke with her briefly. Dassey's brother left at about 5:20 and his mother left at about 5:30. After his brother and mother left, Dassey watched television until about 6 o'clock when he received a call from his brother's boss. After a brief conversation, Dassey returned to watching television until about 7 o'clock when Avery called. Avery invited Dassey over to the bonfire, so Dassey changed clothes. Avery called again and Dassey told him he was on his way. Dassey went to the fire pit by Avery's house, where Avery was burning some branches and tyres. Avery told Dassey that he wanted to pick up the yard, so they drove around in a golf cart for about 45 minutes, picking up things that they could burn: wood, tyres, an old cabinet and a van seat. Avery then asked Dassey to help him clean up something in the garage. Dassey described it as looking like fluid from a car. They used gasoline, paint thinner and bleach, along with his brother's old clothes to clean it up. When done, they threw the clothes on the bonfire. Dassey never asked Avery what it was they were cleaning up. After about 15 minutes of cleaning, Dassey and Avery returned to the bonfire and added some of the debris they gathered from around the yard. They watched the fire until Dassey went home around 10 p.m. Dassey explained that he subsequently lost about 5 or 10 pounds because people had been calling him fat, and he thought his girlfriend broke up with him because of his weight. Dassey denied ever seeing Halbach on 31st of October 2005 and said he did not see her picture or hear her name until after she was reported missing and his mother called him and told him to turn on the news. Asked why he told Wiegert and Fassbender that he participated in the rape and murder of Halbach, Dassey responded, "I don't know." When the investigators during the march when interviewed told him that it was not his fault, Dassey understood that to mean that he would not be taken away from his family and put in jail regardless of what he said. On cross-examination, the state played portions of Dassey's May 13th phone call to his mother. The prosecutor noted that Dassey told his mother in that call that he had been over at Avery's house before he saw his mother at about 5 o'clock. Dassey said that was not true and acknowledged that he had lied to his mother. Dassey said he did not know why he lied to her. The prosecutor also replayed portions of Dassey's March 1st confession to Fassbender and Wiegert. Dassey said he made up the details that he recounted in the confession. Dassey said he did not know why he had made various inculpatory statements. Dassey speculated that the details he provided to investigators might have been gleaned from books, perhaps one called Kiss the Girls. Dassey also acknowledged lying to a detective earlier when he said that during the week after Holbach was last seen, that Avery did not have a fire. When asked why he lied, Dassey explained, "I'm just like my family, I don't like cops." The defence presented the testimony of forensic psychologist Dr. Robert H. Gordon, who examined Dassey. Dr. Gordon testified that certain factors could make a person more suggestible. With respect to some of these characteristics, Dassey tested in the extreme percentiles. For example, when it came to social avoidance, Dassey tested in the first percentile, meaning 99 out of 100 people would grade as more socially outgoing than Dassey. As for social introversion and social alienation, Dassey was in the 2.3 and 1.5 percentiles respectively. Dassey also tested on the low end of the scales for accommodation and deference, and was also found to be passive and subdued. All characteristics, Dr. Gordon opined, were consistent with suggestibility. Intelligence testing indicated that Dassey's intelligence was in the low average to borderline range of the 10th to 13th percentile. Dr. Gordon also noted that minors, even older minors, such as 15 or 16 years old, have a greater likelihood of suggestibility, especially when they have low intellectual functioning, as do people who have had minimal or no contact with the criminal justice system. Dr. Gordon also assessed Dassey using a test developed specifically to measure suggestibility in the context of interrogations. He noted that certain police interrogation techniques could make a person more vulnerable to suggestibility in an interrogation. Such techniques including making promises, telling the subject that he is sure to be convicted, referencing inculpatory information that does not exist, minimizing the seriousness of the offence or the suspect's role in the offence, noting that the suspect did not mean to do it, questioning the suspect about what he would do if he could do it over again, and stating how the suspect's family could be spared if he confessed. Dr. Gordon explained how various segments of the March 1st interrogation exhibited suggestibility. The test used by Dr. Gordon measured two types of suggestibility. By one measure, Dassey was in the 3rd percentile. By the second measure, he was in the 20th percentile. Dr. Gordon acknowledged instances where Dassey resisted certain suggestions. Overall, Dassey tested in the 5th percentile with respect to suggestibility, meaning again, he was more suggestible than 95% of the population. It was Dr. Gordon's conclusion that Dassey was highly suggestible when being interrogated. On cross-examiner, the prosecutor again referred to and quoted from Dassey's May 13, 2006 phone call to his mother, asking Dr. Gordon whether the statements were relevant to an assessment of Dassey's suggestibility. Dr. Gordon agreed that the information was relevant, but stated it did not change his conclusion that Dassey was vulnerable to suggestibility. In closing arguments, Dassey's attorneys highlighted the complete absence of any DNA evidence connecting Dassey to the crimes, despite extensive testing and much evidence connecting Avery to the offences. He also noted the absence of other evidence that he argued would have been found if the events had occurred as Dassey said, and the state alleged it did. For example, Holbach's blood was not found in Avery's bedroom, as would be expected if Holbach had been stabbed and had her throat been cut there, as Dassey said had happened. Defence counsel also focused on evidence showing that the March 1st statements were untrue. He noted Dassey's poor academic performance and intellectual deficits and highlighted how the investigators used techniques that are susceptible to producing a false confession. As for Dassey's May 13th phone call to his mother, counsel noted that Dassey never told her that he did the things he was charged with doing. All he said was that he did some of it, which could mean he stood around the fire and picked up debris in the yard. In rebuttal, the state asserted, why am I hearing this in an Australian accent? Let me say that again. In rebuttal, the state asserted that an innocent person would not confess. I think I've heard that from the Aussie Mark so many times. It's so true. It is just absolute nonsense. Let's carry on. It noted how aspects of Dassey's confession were consistent with the physical evidence. It further noted instances where Dassey resisted suggestions from the investigators. The state was also dismissive of the defence expert's testimony regarding suggestibility. After roughly 5.5 hours of deliberation, the jury found Dassey guilty on all counts. The court sentenced Dassey to life in prison for first-degree intentional homicide, not eligible for release, to extended supervision until November the 1st, 2048. The court further sentenced Dassey to 6 years of imprisonment for mutilating a corpse and 14 years imprisonment for second-degree sexual assault, both to be served concurrent to the murder sentence. Okay, we'll hold it there then, and catch you later for the next part of the decision by Judge Duffin, and catch you again soon. Bye for now.